Hello, and thank you for allowing us to assist you in marketing and selling your real estate. This presentation is about the final stage of this journey and the contract that will govern it. All real estate transactions are governed by written contracts. By law, verbal agreements relating to real estate transactions are not enforceable. Therefore, all real estate contracts must be in writing. In the greater Chicagoland area, contract forms of various realtors associations are used in nearly all residential real estate transactions. The most frequently used are the multi-board residential real estate contract and the residential real estate purchase and sale contract of the Chicago Association of Realtors. In this presentation, we will discuss the terms of the multi-board residential real estate contract, but most of the concepts will also apply to the contract of the Chicago Association of Realtors. However, going forward, the term contract throughout this presentation will specifically mean the multi-board residential real estate contract version 8 form. The contract, first and foremost, will identify the subject real estate and the parties involved in the transaction, and will provide the most important terms of the transaction like the purchase price, the earnest money amount, and the date of the closing. It will spell out additional terms after that. The terms of the contract will hardly be final when the buyer's offer is accepted by the seller in writing, resulting in an enforceable contract. This contract includes terms that may result in various points of potential renegotiation of the purchase price or other terms of the contract after it is signed. The first point at which the terms of the contract are subject to renegotiation is based on the attorney review and inspections paragraphs of the contract. According to the attorney review clause of the contract, an attorney representing either party can either propose modifications to the contract or can disapprove the contract altogether within 5 business days from the date of acceptance. However, this deadline is itself subject to a proposed extension pursuant to the attorney review. Modifications may be proposed with respect to any term of the contract except to the purchase price. Although the attorney review does not technically permit either party to terminate the contract based solely on the purchase price and does not permit either party to propose a modification of the purchase price, in practice, the attorney review frequently is used to renegotiate the purchase price indirectly, which we will discuss later. Most attorneys will propose modifications to the contract and will have to respond to the attorney review modifications requested by the other side. Therefore, anyone involved in a real estate transaction is advised to be represented by an experienced real estate attorney. Once attorney review proposals are made, the contract is cancelable by either party at any time until all proposals are conclusively resolved by a mutual agreement of both parties. The contract may also allow buyers to hire a licensed home inspector to inspect the condition of the real estate improvements and issue a report. This inspection can be waived by the buyer at the time of the initial contract negotiations, which would be confirmed by placing initials of both parties in the appropriate section of the contract. If the home inspection is not waived, buyer has a right to conduct an inspection either with a right to request repairs or credits in lieu of repairs based on the inspection results or without a right to make such requests. Importantly, buyer must not share the inspection report itself with seller unless the seller explicitly requests it. The professional home inspection is to be conducted within 5 business days from the date of acceptance, but this deadline may be subject to an extension under the attorney review. Unless explicitly waived, buyer's right to inspect will be preserved even if the contract stipulates that buyer is accepting the real estate in as-is condition. Buyers sometimes request repairs and/or credits in lieu of repairs based on the inspection results by using the attorney review even if the contract is subject to the as-is provisions and even if the contract is subject to the professional inspection without requests. The contract will remain subject to cancellation by either party at any time before all inspection issues timely raised by the buyer are conclusively resolved by a mutual agreement of both parties. The purchase price may be subject to another point of renegotiation in transactions subject to the financing contingency in which buyer's obligation to buy the real estate is contingent upon buyer's ability to obtain a loan. Most lenders will require that an appraisal of the real estate be performed by an independent licensed appraiser and that the real estate appraise at least at the purchase price. Occasionally, a lender will waive an appraisal, but this happens in the minority of the residential real estate transactions. If the real estate does not appraise at the purchase price or higher, buyer's financing will not be approved and the transaction will fall through unless either party or both parties cover the difference between the purchase price and the appraised value. The buyer may cover this difference by increasing the down payment, but the buyer is not required to do it unless an appraisal addendum is part of the contract. The seller may cover the difference between the purchase price and the appraised value by lowering the purchase price to the appraised value. Finally, the parties may agree that each will participate financially to some extent to cover the difference between the purchase price and the appraised value. In any event, the contract will remain subject to cancellation by either party at any time until the low appraisal issue is conclusively resolved by a mutual agreement of both parties. If the contract is canceled pursuant to the attorney review, based on the inspections issues, or due to a low appraisal because the parties are unable to resolve the underlying issues, the earnest money has to be returned to the buyer, and the seller will have to start the process of finding a new buyer and negotiating a new contract from scratch. Some methods exist to limit the instances at which the terms of the contract may be renegotiated and the contract itself canceled. One such method is for seller to accept only cash offers, but this may not be realistic in situations where no cash offers are presented or where cash offers presented are substantially deficient vis-à-vis other offers based on the purchase price or other terms. Another method with respect to the appraisal is to negotiate and sign an appraisal addendum, which will require the buyer to cover a potential difference between the purchase price and a low appraised value up to a certain amount. Yet another method is to require a waiver of the professional inspection from potential buyers, but this may be most realistic when the real estate is in a dilapidated condition or otherwise distressed, therefore most likely to be purchased by rehabbers and flippers and discounted accordingly. In normal situations, sellers' insistence on a waiver of the professional inspection could be a red flag to potential buyers, as they are likely to interpret sellers' request to waive the inspection as a signal that serious defects affect the real estate and the seller does not want them to be discovered. Therefore, in most standard residential real estate transactions, sellers may be well advised to forego such methods of eliminating the renegotiation points and simply accept the fact that the transaction will be subject to potential renegotiation that may affect the purchase price. The risk of contract cancellation will then have to be minimized in reliance on an experienced realtor with assistance of an experienced real estate attorney who will both help the seller to navigate through the renegotiation points as well as through various other potential contingencies, which we will discuss shortly. Perhaps the most effective method of minimizing sellers' risks arising from the terms of this contract and the renegotiation points built into it is to thoroughly screen the potential buyers and their offers at the time when the initial terms of the contract are negotiated. This due diligence involves requiring cash buyers to present proof of sufficient funds for the purchase, and from buyers that need to obtain a loan, to present a loan pre-approval. The loan pre-approval letters should be carefully reviewed to make sure that they were issued based on the actual, careful, and detailed review of the potential buyer's financial situation, including their credit rating and history, their income and expenses, and their assets and liabilities, with all of the above substantiated with proper documentation and not based merely on a verbal verification conducted by a mortgage professional with the potential buyer over the phone. It is imperative that the approval letter be issued by a reputable lender or mortgage broker, which can be confirmed by communication between the seller's realtor and the buyer's loan professional. Going back to the first page of the contract, which contains some of the most important terms of the transaction, it also provides for a potential credit from seller to buyer and potential commission to be paid by seller to the buyer's real estate broker. If the contract provides for a credit from seller to buyer, which is usually utilized to assist a buyer of limited financial resources with a down payment and closing costs, it is important for the seller to realize that the effective price will be lowered by the amount of the credit. Under such scenario, the true sale price is the purchase price stated in the contract minus the amount of the credit. The credit amount is effectively the money that the seller gives back to the buyer. Any commission to be paid by seller to the buyer's real estate broker is negotiable. Even though sellers do not have to offer to pay any commission to the buyer's real estate broker, sellers often do so in order to increase their chances of finding a buyer within a reasonable time and successfully closing the sale. If seller does not agree to pay any commission to the buyer's broker, it will have to be paid by the buyer. Buyers have many other substantial costs to cover with a real estate purchase, including loan procurement costs and title company charges. Sellers' unwillingness to pay for all or some of the buyer's real estate broker's commission could be a great eliminating factor, especially in transactions that have to be financed and that involve buyers with limited financial means, because the purchase will not be affordable for too many otherwise qualified buyers. Unless the real estate is likely to bring in cash buyers or otherwise financially strong buyers, it may be advisable for the seller to offer to pay for all or some of the buyer's broker's commission and compensate for it by increasing their asking price or by being less flexible in price negotiations. In the greater Chicagoland area, the commission of the buyer's brokerage paid by a seller willing to do it has historically been at or about 2.5% of the sale price. In the end, the decision as to whether to compensate the buyer's brokerage and, if so, in what amount, whether said amount is stated in terms of the percentage of the sale price, fixed amount, or otherwise, is completely up to the seller. It is our opinion that sellers should insist on a reasonable amount of the earnest money from potential buyers. So, the earnest money should be sufficiently substantial in transactions involving cash buyers, as well as the buyers able to put a high amount of the down payment. Buyer's unwillingness to deposit a reasonable amount of the earnest money may indicate that he or she is not serious about the proposed transaction. Sellers should be more flexible with this requirement in transactions involving buyers that have to obtain a loan and who have limited financial resources. It would not make much sense to require the earnest money in the amount of 20% of the purchase price from a buyer who can only afford a 5% of the purchase price for a down payment. This issue should be carefully considered on a case-by-case basis. Besides the purchase price, the earnest money amount is one of many important factors that sellers should carefully evaluate when deciding which offer to accept in a multiple offer situation. This section of the contract allows to check off the items of the personal property that will be conveyed from seller to buyer along with the real estate, including any appliances. It also has space to insert any items of the personal property that will be a part of the sale but are not specifically listed to be checked off, and space to insert any items that are specifically excluded from the sale. This section should also specify any items of personal property that are not in operating condition. Seller warrants to the buyer that all items of personal property sold to buyer along with the real estate will be in operating condition at the time of closing unless the contract is subject to as-is provisions or unless the contract explicitly states so here. By placing initials next to the applicable paragraphs, the parties to the transaction will confirm whether or not the contract is subject to procurement of a loan by the buyer. If the transaction is subject to the financing contingency, the contract will specify the loan terms to be accepted by the buyer, including the type of the loan, the amount of the loan, annual interest rate, the term of the loan, and any discount points to be paid by the buyer. These loan terms should match the loan terms prevailing in the marketplace, as well as the terms of buyer's loan pre-approval. This paragraph will also specify a deadline by which the buyer is to secure the loan. If buyer is not approved for the loan by this deadline, the buyer will either cancel the transaction or ask the seller for an extension of time to secure a loan. If seller does not agree to an extension, buyer will likely have no choice but to cancel the contract. So, in addition to the various renegotiation points we have already discussed, the financing contingency is another feature of the transaction that may lead to a termination of the contract if the buyer is unable to obtain the required financing. For this reason, it is critical to carefully review the potential buyer's loan pre-approval at the time when offers are considered. By doing so, the risk of contract cancellation based on buyer's inability to obtain the necessary financing can be limited, but unfortunately, it cannot be eliminated. This is why some sellers may prefer cash offers at a lower sale price to offers with a higher sale price but subject to a financing contingency. This is often so, even though sellers will have to pay half of the title company's closing fee in a cash transaction, while this fee is paid by the buyers in its entirety in transactions with a loan. The contract is further contingent upon buyer's confirmation of the insurability of the real estate and buyer's confirmation that the real estate is not located in a flood zone. Buyer may also cancel the contract based on these contingencies, but this does not happen often because it is usually known up front whether the real estate may have insurability issues and whether the real estate is located in a flood zone. This may get a bit trickier if the real estate is part of a condominium or townhouse association, because the issues of insurability or flood zone pertain not just to the real estate proper, but also to the common elements or other properties within the association. Speaking of associations, the contract will be specifically contingent upon buyer's satisfactory review of the association's documents and information if the real estate is part of any condominium, townhome, or homeowners association. In order to satisfy this contingency, the seller will have to provide the buyer with the association documents at seller's cost. If specifically so negotiated, the contract will also be subject to the sale of buyer's current property. This contingency will allow the buyer to back out of the contract if buyer is unable to sell the currently owned property by the deadline provided in the contract, or at the minimum, buyer will request additional time to sell. The earnest money will have to be returned to the buyer if buyer timely cancels the contract based on any of these contingencies. A property tax credit that seller will have to give buyer at closing will usually be one of the substantial costs of the transaction. This arises from the fact that in the state of Illinois, the property taxes are paid in arrears, which means that this year we're paying for the prior year's taxes, and that the property taxes for this year will be billed and payable next year. As a result, without a credit, buyer would end up paying after the closing for the property taxes belonging to the seller. Therefore, the contract requires that the seller give the buyer a credit prorated through the date of closing for the property taxes that are not yet due and payable at the time of closing. This way, buyer receives from seller at closing funds to pay after the closing for the property taxes that belong to the seller. This tax is usually calculated based on the last known full-year property tax amount plus a customary 5 to 10% to cover any increase. The actual credit amount will depend on the amount of the property taxes, but will often be in thousands of dollars. This property tax credit issue may be additionally complicated by the fact that the seller is receiving tax exemptions, especially senior freeze, or by the fact that the closing date falls within a reassessment year and the reassessment results will not be known by the time of closing. These intricacies are beyond the scope of our discussion, but this is one of the areas where assistance of an experienced real estate attorney may be very helpful. The bottom line is that sellers should be aware of this substantial cost item that they will have to cover at the closing and that will lower the amount of net proceeds they will realize from the sale. The contract provides that the seller is to obtain a title report, known as a title commitment, from a title company licensed to conduct business in Illinois, that the seller provide title insurance for the buyer, and that seller furnish the buyer with a plat of survey, all at seller's expense. The total cost to the title company will depend on the purchase price as the title company closing fee and the title insurance premium increases with a higher purchase price. Nevertheless, the title and survey costs will total several $1,000s. We believe that it is important for sellers to know what approximate costs affecting their bottom line they should expect, including what will be the approximate title and survey costs, in addition to any real estate broker's commission, property tax credit, transfer stamps, and other expected costs of the transaction. This is why we always attempt to provide sellers with as much information regarding their expected costs as we can from the beginning of our involvement with them. To this end, we provide our sellers with disclosures and initial closing statement. These disclosures and the initial closing statement will be based on the stated asking price and on various other assumptions, and to that extent will not be exact, but should still give our sellers a good approximation of the expected costs of the sale. Paragraph 24 of the contract lists a number of representations which sellers automatically give their buyers when they enter into the contract. It is imperative for sellers to review these representations carefully to make absolutely sure that they are true, accurate, and complete as they pertain to them and to the real estate. If any of the representations are not completely true, accurate, and complete, it is crucial for this to be addressed during the initial contract negotiations by modifying the contract form or by signing an addendum, or at the latest during the attorney review. It is also especially important for sellers to read very carefully and to complete correctly and truthfully any disclosures applicable to the transaction, including the residential real property disclosure report, disclosure of information on radon hazards, and/or lead-based paint disclosure. This is absolutely critical, as providing any false information, whether intentionally or inadvertently, may expose sellers to liability. This presentation is not intended to be a comprehensive discussion of the entire contract, but instead is meant to provide limited highlights of the most important terms of the contract that are most consequential to sellers and to provide sellers with a general understanding of the contract, specifically as it relates to its finality and enforceability. This presentation is not intended to be used in lieu of reading the Multi-Board Residential Real Estate Contract Version 8 form, but rather it is intended to be used as a supplement in addition to reading this contract form. Sellers are urged to read the entire offers from the potential buyers, which may be presented utilizing this contract form or a different form, and to seek advice of a licensed real estate broker and a real estate attorney to obtain answers to any questions and to address any concerns. If you have any questions about this presentation or about the process of selling your real estate, please contact us by calling 847-954-2200 or emailing us at ateam@realtogy.com or by contacting directly your Realtogy A-Team member.